Hi, everyone. Welcome to our webinar. I am Kelly Mylink. I am a partner in the Business Immigration and Global Mobility Group here at Husch Blackwell. Before we begin, I need to go over some housekeeping items with you. So if you've been through our webinar before, you know there's some things we just want to make sure you're aware of. If at the bottom of your audience console, there are multiple application buttons for you to use during the program today. And if you have any questions during the webcast, please, if you have questions, this is a very complex topic. There's a lot of questions that I know that you all have kind of lingering in the back of your minds. So please submit them in the question box. We will try to answer as many of those as we can during the webcast today. And if we can't, we'll answer them later via email. A PDF of the presentation is available in the program materials folder. Auto-generated closed captions are available for today's program, and to turn those on, you click the CC button at the bottom right corner of the media player box. The program has been approved for legal education hours. For live attendees, you report your hours by clicking on the CEU icon. It's at the bottom of your screen, and then a certificate of attendance, including course numbers, will be emailed to you tomorrow, along with the recording of the webcast for watching and sharing. Towards the end of the program, please complete our short survey. We want to use your feedback to plan sort of future programs. If there's a topic you want us to dive more into, please put that in our survey because that helps us plan our future programs. And then I think that's it. So we'll go ahead and get started with our program today. So today's webinar, we're going to sort of unpack some of those immigration policy shifts you've been hearing about and trying to understand what to expect, how to protect your organization, how to react to these immigration policy changes that are playing out sort of in the real world today. With me today, I have Tiffany Baldwin. Tiffany is a senior counsel in our Business Immigration and Global Mobility Group. She has more than 25 years of experience in immigration law. She helps find solutions to all clients in all industries to their employment needs with respect to immigration law, workplace compliance, everything in the business immigration world. Tiffany does a majority of her work with health systems, physician provider groups, and other healthcare clients, as well as colleges and universities. That is her specialty here. So I know we have a lot of you on as well. So she is happy to answer all of those questions. So today we have a lot to cover. This is our agenda. It looks short, but it's actually quite a lot to cover today. We're going to talk a little bit about sort of an overview of ICE enforcement actions. What is going on the ground? What do you need to know? There's a lot of anxiety out there, right? You're seeing things in the media. We're going to talk a little bit about what's going on in the ground in the real world, and then talk a little bit about how your organizations should react or how you can prepare for a potential enforcement action by ICE. We're also going to talk about more immigration compliance topic of I-9s and I-9 audits. I-9s, E-Verify, all of that, what's going on. Again, it's an important piece of sort of that workplace compliance. It's an important piece and it's related to the ICE enforcement actions. So we're going to talk about those a little bit too. Then we're going to talk about recent developments and sort of travel and visa restrictions. So individuals who are trying to get into the US, what is going on? Are they going to have trouble getting visas? Are we going to have difficulty traveling, getting into the U.S.? What's going on at Customs and Border Protection when you reach the airport or reach the border? We'll talk about some of those recent developments. Finally, we'll talk more specifically about visas. Some of you have, not a lot of you colleges and universities are on the call, but some of you who are in other industries who have H-1B lottery registrations in the past 3 weeks. You've been submitting those. We'll talk about that. But we'll also talk about some of the other non-immigrant visa updates and sort of what's going on in that world and what changes to expect. With that, I am going to stop talking. I am going to turn this over to Tiffany to start us with the ICE enforcement actions and what you all should know.
Okay. Good afternoon, everyone, or good morning if you're on the West Coast. I'm Tiffany Baldwin, and yeah, we got a little bit of shock and awe, right, in the first couple weeks and the first 2 months of the second Trump administration. And one of those things has to do with immigration. The campaign goal was 1 million undocumented immigrants a year to be deported, and they're working their way towards that. And one piece of that are workplace enforcement, or ICE raids, if you want to call them that. And so we are seeing a little bit more of that, but for the most part right now, because we're only 2 months in, we're still just seeing kind of the general capturing of undocumented persons, not necessarily at the workplace. So I think there was like a 600% increase in the number of undocumented that had been detained for removal just in the first 2 months of this administration. And the reason why they're not yet at the work sites, not so much, is because it takes a while to investigate and create the investigation to then go ahead and do those enforcement efforts at the work sites. So now is the time to plan for a possible work site. Kelly's going to talk a little bit about compliance in our next segment, and that's that part. And then now, while maybe they're not at work sites so much right now, we'll talk about preparing your staff and your offices for those enforcement efforts. One, I'm sure many of you have policies and a communication plan for dealing with law enforcement. Look over those plans, make sure that they're up to date. ICE doesn't have any additional authority over any other law enforcement agency. FBI, your local police, sheriff's office, all require warrants. They all have limitations and such. I think the slight difference with ICE is that they also have other avenues to come into the workplace through administrative warrants, which I will talk about later, that deal exclusively with kind of the immigration violations, which are civil in nature, as opposed to judicial warrants, which are criminal in nature. So you should have a policy in place that deals with, who's going to be a point of contact, what should individuals at your work sites do when ICE comes to calling, and also a communication plan so that there's kind of you control the communication in and out, so it's consistent. A key thing is to create some sort of response team. So a group of individuals that will communicate with legal counsel and will deal with law enforcement directly. So they will contact it at the beginning when ICE first comes aboard, and then and kind of take it from there and be able to review warrants and make those determinations in coordination with legal counsel. A key thing is that law enforcement, including ICE, they don't need a warrant to be in your public spaces. So parking lot, lobbies that are open to the public, courtyards, cafeterias, they can be wherever the public can be. They can't be in private spaces without a warrant. And sometimes some of those private spaces are very obvious, right? There's locked access, key card access. That's an obvious private spaces. There are some spaces that are kind of ambiguous, and you can decide to kind of designate them as private spaces by signage. For instance, you might have a classroom building that's open to the public, like you don't need a key card to get in, but you want those lecture halls or those classrooms to be private. So you might put signage on each of the doors saying, entry for students and faculty and invited guests or something like that. something to designate that when you enter this space, you have the expectation of privacy. And that distinguishes where law enforcement can go versus without a warrant and where they can go with a warrant. Another thing is that oh, go ahead.
Oh, I was going to say, one thing to pay attention to is it's not that they're going to stop if they don't have a warrant, right? If somebody says, hey, sure, come on in, they're going to go right in. So that communications plan that Tiffany was talking about becomes very important, because if somebody opens the door for them, oh yeah, they'll go right in.
Yeah. Thank you for bringing that up. Yeah. Yeah. So some people are just, very helpful, and they don't, and sometimes the law enforcement, they are not obviously law enforcement. They may be wearing street clothes. And so it's very easy to be, oh yeah, you're coming in with me. And then once they're in, right? So that's where staff training in particular comes into play. I think these issues are very kind of anxiety producing and nerve wracking. And if they know what the plan is, they know what they can do and what they shouldn't be doing, and what the law enforcement can do and what they shouldn't be doing, I think it takes the level of anxiety down on these issues. Okay, so I'm going to kind of go back, since there's an issue about private. So private university, that doesn't necessarily mean everything on campus is private, because, anyone can walk onto campus. It's really kind of the spaces that are designated as you have the expectation of privacy. It's not a public-private in a corporate sense. It is whether you have the expectation of privacy versus, a conversation, anyone that overhears it, that's public. So that's kind of the difference. It's not a corporate designation differentiation. It's really kind of the expectation of what you do and say and have on you that is either available to other people, or it's private and it's secure. So for staff training, again, there should always be a point of contact. So that might be where the kind of building that team comes in. So you have a list of, there should always be a designated person whenever a business is open. So if there's a third shift, there needs to be a third shift point of contact. Know that all persons have a constitutional right to remain silent, and they don't have to answer questions if they don't want to. You don't advise them, don't answer any questions whatsoever. They have that personal choice, but they may not have authorization to provide information, and that could be made clear, but they can not say anything if they don't want to. So that also kind of alleviates some anxiety. To know, again, the public-private spaces to keep law enforcement out of. And another thing is plain view. So, people tend to know that, oh, well, if law enforcement sees a document that may lead them to, want more evidence, that's called the plain sight rule. It's also hearing. So a group of nurses that are talking about the law enforcement officer coming in and talking about, oh, that patient from Guatemala in the, waiting room or whatever. If they can hear that, that is considered in plain sight or in plain hearing. So know that they should maybe turn off monitors if law enforcement can see them, or put files away, or keep conversations to a minimum. I think I got cut off. And if it seems as if there's going to be an uptick in worksite enforcement efforts near you, you might want to conduct some practice drills. Again, that usually it takes the anxiety down, because people are like, oh, I got this. So there's that. Oh boy, I got small. So when ICE comes, there's kind of multiple documents that they can bring with them. and that gives them different levels of authority. The biggest one is a judicial warrant. It's an arrest warrant or a search and seizure warrant, and it's signed by a judge or magistrate. So it comes from the court. In order to get that, ICE would need to show like probable cause that that person needs to be arrested, or probable cause that they need to access that evidence. They present that. It shows the location, what's the search and seizure, or the person. So it will be limited. That's their entry ticket, right? That you can't stop them from executing a judicial warrant. So when they have that, that's, when the point of contact sees the judicial warrant and knows that everything, checks all the boxes, then that's permitted action on law enforcement. ICE will also have an administrative arrest warrant. It's not a judicial warrant. It's signed by like an ICE supervisor. It's that this person is, we believe to be unauthorized in this country, so you can detain them wherever they may be. That is where the employer, the university, the hospital will have the option. They can consent to let them execute that warrant, but they also have they also have the ability to say, you don't have a judicial warrant, so we're not going to authorize you to enter the private space. I think each individual kind of instance is going to be, you're going to have to weigh that. It may be the end of a shift, and so ICE could just wait out in the parking lot and execute the warrant then. It may be that, you can maybe negotiate that, give us a copy of the warrant, we'll make sure that this individual contacts their attorney and make sure that they, arrange this. That was advice I got from a white-collar attorney, white-collar crime attorney. So there are ways to kind of be a little bit flexible. Again, it's going to be a case-by-case basis or a company policy by company basis. There's also the judicial subpoena, again, signed by a judge, and that's really more kind of compels testimony or production of certain documents. That's not always an immediate, giving the documents. It can be challenged in court, but again, that rises to the same level as a judicial arrest warrant. And then, sorry, the slide got cut off. A subpoena or a notice of inspection. So this is really, we want to see your I-9s. And again, Kelly's going to talk about that a little bit later. But again, that's not an immediate, that doesn't require immediate compliance. Usually there's 3 days unless otherwise stated. So those are the, and the point of contact needs to know the difference between those.
Tiffany, before you transition into the next slide, I want to make a quick note, because I think some of the questions, we focus on, okay, what's the type of warrant? What do we do with the different documents? But I mean, in reality, what we're seeing is, ICE often shows up and they don't have anything at all. They're just, they may just want some information. We had one situation where ICE showed up and just said, I want to let you know that you have undocumented people here. And they didn't give any names. They didn't say anything else, just want to let you know you could be subject to an I-9 audit, just letting you know that. And then they left, and that was it. That was the extent. So I mean, there are various different reasons that ICE comes on site. I think having knowledge of all of these warrants and the difference of them and what to do and thinking through that is really, really important for your organization. But also consider that a lot of times they just show up without anything at all. They just have a list of names of people that they have been directed by their supervisor that they either need to arrest or question, or maybe they need to let you know something, or maybe they're trying to gather information for their investigation. And then you have to decide, okay, well, do we want to push back and say, hey, we at least need an administrative warrant, give us something from the federal agency that you're with, which would be Department of Homeland Security, or you know what, actually we can't give any information out without a judicial warrant, so go get something signed by a judge. And that's kind of something that you as an organization need to think about, as Tiffany said. And it's important to know that there's sort of 3 levels. You have the ICE coming and not having any paperwork, the ICE coming with the administrative warrant, and how do you want to handle that, and then ICE coming with a judicial warrant, which is more of a, that's requires that legal compliance that is probably going to be a decision made for you.
Yeah, and there's other considerations when it comes to that kind of that flexibility, the administrative warrant or no warrant at all. And that may be if you have other laws that kind of limit. So you are a school and there's FERPA issues, or a hospital and HIPAA issues, or in some states, there are employee privacy laws that you have to abide by. And how does that, you know, how does letting them in, even if they don't have a judicial warrant, conflict with maybe some of those other privacy, confidentiality concerns? Yeah, but sometimes, yes, they just show up. But that was really good that they kind of gave your clients a heads up on their workers, Kelly. So if ICE is there, again, there should be kind of someone taking notes, documenting their presence. And if they're executing a warrant, there should be someone always accompanying the agents. If it looks like they are going outside the scope of their warrant, you can say, I'm objecting to this, but you can't do anything to interfere with them. So even if you think that they're, you know, going outside the box, you can't interfere. So that's also one consideration with the administrative warrants, is that once they're in, they're in. But again, you can still make your objections known for the record. Also recording and monitoring activity. Obviously, you can visually monitor. You can also record, but again, that may be, that might be a case-by-case basis, as well as deciding who is going to do the recording. So there might be some individuals within your workplace that might be hassled less with recording versus someone else. This is kind of obvious. Don't hide employees, don't destroy documents, don't lie, don't provide false information. That's, just sometimes they are just there and they're going to follow their parameters and do what they need to do. And you just want to make sure that your workplace is protected as a result. Okay. And then after they leave, you want to, kind of do a recap, prepare a written report, and notice certain things like, did they have their ICE uniforms on, or did they come in plain clothes? Did they bring in local law enforcement? And in particular, and this is very important, especially after, these last 2 months, is that if they are arresting one of your employees, make sure you know where they're being taken so they can inform their family and attorney. And if it seems like this information has gotten out to the public that ICE was on your campus or at your workplace, then you need to evaluate whether you need to make a statement or or you need to alleviate concerns of your own employees or your students or parents or patients, whoever it may be. So you need to determine whether or not you need to kind of recap with other stakeholders within your environment. Okay. This is our little pop quiz. In what year was ICE established? And I will give you a hint. It was established with the DHS, when the DHS was established. So make your guesses. And it doesn't have to be in a form of a question. Let's see if we can answer some questions in the meantime. Let's see.
There's a lot of questions about the public-private distinction, and they're hard to answer, right? I mean, so a lot of, where you have a reasonable expectation of privacy, and you're trying to figure that out. But I mean, the best thing you can do, right, as Tiffany said, is signage, saying only authorized personnel, only authorized employees, doors that are locked that only certain people have key cards to. It's having a sign-in log at your reception desk, right? So not letting anybody pass the reception without seeing who they are and seeing if they're on your invited guest list. And then if they're not, then that kind of, having that sort of first point of contact to the extent you can, and then having the person who's at the desk know who to call when ICE is there can be helpful.
But that seems with all these questions, it might be good for, a deep dive into that private space and putting that up on our resource page.
All right. Okay.
Okay. Let's see. Oh, here we go. Sorry. Okay. Oh, very good. Yes, it is 2003. It was March of 2003. So good job. For about 15 years, though, after, people still referred to ICE and USCIS and CBP under INS, like on TV and in movies. So finally, 20-something years later, we all got terminology.
They've been on the news too much.
Yeah, exactly. So I mentioned compliance is a great way to help prepare for ICE audits. And Kelly is going to talk about that now.
All right. I-9s. How fun. I do a lot of workplace compliance stuff. I love I-9s. Not everyone does, but I love getting I-9 questions because this is probably one of the only areas of immigration law where it's a little bit more black and white, not completely, but usually we can at least get to an answer or a solution we all feel comfortable with. A lot of other areas of immigration, there's a lot of gray area. There's a lot of ways policy can shift. Forms I-9 are a little bit different, and it's kind of a nice break from the ambiguity or that comes with some of the other immigration policy things. So I-9s are important, right? We're talking about how we protect our organization and how we're thinking about, okay, we could have people on site or people working for us who may not have valid work authorization. They might be undocumented and we don't know about that. How can we find out? You do that through your I-9 process, right? So the Form I-9 is, for those of you who are not in that world, it is the form established in 1986 that every employer has to verify the work authorization and identity of every single employee that works for them. Employee is important. You don't have to do that for independent contractors, but you do have to do that for employees. And it's a very short form. Used to be 2 pages, is now currently just 1 page. So it's very, very short, but it's also very, very complicated. But you use this form to verify that everyone who is working for you has the right documentation to show that they are who they say they are and that they're eligible to work for you. There's some caveats to that, right? I-9 cannot, that form cannot, if somebody's using a false identity, right? They're using somebody else's name, they're using somebody else's social security number, and they present themselves as somebody else. You're not going to catch that because those documents might look real. And that's okay, because as long as you, as the employer, did what you were supposed to do with the I-9, you completed it accurately and completely, and you had no other knowledge that that person was not who they said they are, you as an organization have protected yourself. You've done everything you could, you could enroll in E-Verify too, but even E-Verify may not catch it. You've done everything you can to protect yourself as an organization, to say, we did everything we were legally responsible to do to make sure that we had an authorized workforce. So when we talk about preparedness, Forms I-9 are kind of part and parcel to that in preparedness. Okay, I-9s. Oddly enough, I-9s are really part of immigration law. And it's kind of confusing because you think, well, it seems like an employment form. It is, but it's also established as part of immigration law. It is enforced by Immigration and Customs Enforcement and Homeland Security investigations, ICE and HSI. We've been talking about ICE. HSI is sort of a component that does sort of internal workplace investigations. And both of them are part of U.S. Citizenship and Immigration Services, and you go above that, it's all part of the Department of Homeland Security. The Department of Justice Immigrant and Employee Rights section handles discrimination charges. So, for example, you, as an employer, you say you have somebody and they presented to you, for example, everyone who presents a permanent residence card, you ask for additional documentation to prove their permanent residence. That could be considered discriminatory because you are asking permanent residents to provide more or different documents that you would others. And that could result in an investigation by the Department of Justice in this Immigrant and Employee Rights section. I know that you've probably heard some things in the news about the Civil Rights Division and what their priority is going to be. Most of the laws, the anti-discrimination laws under immigration, are protecting U.S. citizens, permanent residents, asylees, refugees, so those who have sort of are non-visa holders. So I suspect we'll still see a lot of those discrimination charges, those investigations of treating U.S. citizens or permanent residents or preferring H-1B workers over a U.S. citizen. That could be some investigations that we see out of that department. But the Department of Justice is involved in sort of the same anti-discrimination in the immigration context. And it's all part of the same law that establishes the Form I-9. And usually those types of violations are discovered through how you complete Form I-9, right? Asking for those more or different documents of certain people who look a certain way. You ask for more different documentation. So all of that comes to play with the Department of Justice and their sort of investigatory unit there. Finally, the Department of Labor is tangentially involved. They sometimes, if there are as part of an I-9 and audit and investigation, they're going to ask for a wealth of documents. If they see things that might be a wage and hour violation or other type of violation in the employment context, they will refer it over to the Department of Labor. So we call them kind of secondary enforcement. They're involved in this because things can snowball really fast in the I-9 world. Okay. What triggers an I-9 audit? Most of the time, a lot of are sometimes existing investigations, right? An employee complains to immigration or to the Department of Justice, or job candidates have grievances that they were discriminated against. We did have this in one case where, and we see this a lot, where there are groups of U.S. citizens who will say, well, I was discriminated against as a candidate and you hired a bunch of H-1B workers over me as a U.S. citizen, and you're preferring, foreign workers, you're going to pay them less. So that can sometimes happen. We see those investigations every once in a while, and that can trigger an I-9 audit. Complaints could involve third-party contractors. That's one thing we see quite a bit. So if you use a staffing company, for example, if you're a hospital and you use a staffing company for cleaning services and they have an investigation pending against them, they might come to the hospital and say, we're going to do a complete I-9 audit of you all, even though we're really looking into the staffing company. Also, just sort of data analysis. So certain high-risk industries, agriculture, hospitality, manufacturing, can be retail, are all at sort of a higher risk there and always really have been. Compliance hotspots by geographic location. Sometimes they just designate a certain geographic location and they say, you know what, we're going to do a bunch of audits here. We're going to send our resources here. And this is where we're going to sort of do all of our compliance here. And usually we just start hearing about that. It's not announced, right? All of a sudden, 3 businesses get a notice of inspection, and then it's more, and then it's more, right? That's how we hear about it. Previous audit history. So for example, if you have been audited before and didn't have a very successful audit, you are ripe for another one to make sure that you continue on the path to compliance. And then E-Verify referrals. So even E-Verify, if you use E-Verify, E-Verify will check you with an E-Verify desk audit. That's how they kind of check different organizations. And then those desk audits can turn into Form I-9 audits and inspections. So in the E-Verify context, E-Verify has algorithms that they use. And when you input information in E-Verify, it takes all of the information from the I-9. That's what you're entering into in E-Verify. You're using the information directly from the I-9 form, and you're inputting it into E-Verify. And so E-Verify has certain algorithms. So for example, if it sees the same combination of documents. So in the I-9 context, you tell everyone to provide their driver's license and social security card. And so you have a series of E-Verify records where the documents that were presented were a driver's license and social security card, and that's 95% of your I-9s as shown in E-Verify. That can trigger an audit. That can trigger a desk review because they're saying, well, are you telling all of your employees to present a driver's license and a social security card for Form I-9? When employees should be given the choice, right? Some employees may not have a driver's license, so they present an ID card or they present an employment authorization document, for example. So there's all sorts of things that they can provide as part of the Form I-9 process to verify their identity and work authorization. But if it looks like you're not really giving them the choice, the algorithm in E-Verify will catch that, and that could trigger 1, an E-Verify desk audit, and 2, a Form I-9 audit. All right. Other agencies can refer over for I-9 audits. You can be referred from Department of Justice or state law enforcement agencies. So if state law enforcement agencies get complaints about, hey, I know a bunch of people over here are using fake IDs, or they're investigating somebody who is producing those false identification documents, then they may refer that to ICE, and then that turns into an I-9 audit. So certainly all of those things can trigger the audit.
Kelly, I just want to jump in here.
Yeah.
Some state workforce development agencies will do their own like little spot audits, and sometimes that will then turn into a federal one. And 2 other developments just in the last 2 months. One, Attorney General just came out with a memo, among other things, going to require U.S. attorneys to report to her quarterly on arrests and cases, and so we might see an uptick from that referral source. There is also this push right now. IRS can't release any IRS data to other federal agencies, and there is now kind of negotiations or that push to let that information sharing, and that will probably trigger a slew of I-9 audits if that goes through.
Yeah, and that actually raises an important point, because part of their investigatory powers, right? I-9 audit is one investigatory power by Department of Homeland Security, but we're also seeing sort of other agencies kind of come in here, as Tiffany mentioned. And another one that we see that hasn't yet turned into an I-9 audit sort of referral source, but it could, is getting those. We have more companies and organizations getting letters from the Social Security Administration saying there's been a mismatch of an employee's identity and work authorization documentation. So maybe their birth date, their name, and their work document doesn't match up. We've had some different types of letters asking for information from the Social Security Administration. Happy to talk about those fun letters offline at any point in time, but some different letters that we have not seen before from the Social Security Administration, which kind of indicates to us that they're using that as sort of a part of their investigatory powers, or a referral that could turn into an I-9 audit in the future. So for those of you wondering, you're thinking, okay, well, we haven't had an I-9 audit yet. What could happen? What should I expect? It's fairly straightforward, the process that they use. They will issue a subpoena and notice of inspection. And the most important thing to know about that is that you have 3 business days to respond. And so you don't have to go around and try to get all of your documents all together all at once. You have time. So take a step back, breathe, say thank you, and we'll answer this in due course. I have 3 business days. That notice of inspection will contain a list of documents that they want to see. It will be all of your I-9s, and those can be for a certain date range. They can be for a certain entity. If you're sort of one entity and you've got multiple subsidiaries or something, they can target one subsidiary, or they can target the entire organization. It's good to clarify that with the ICE auditor. They'll ask for quarterly tax statements. They'll ask for lists of subcontractors. They'll ask for payroll statements. Affiliated business entities. They'll want to see your whole org chart, business registration documents. So the list goes on and on. It's not just your Forms I-9. Usually, again, that's a broad approach of things that they're asking for. In addition, so you have 3 days. So again, you have those 3 days to respond, right? And then you're going to present all of those documentations to the ICE auditor or the ICE agent assigned, who will then hand it all over to an auditor. And that auditor is going to take his or her sweet time working through that documentation. You might not hear you might hear something in 3 months, which great. It could be 2 years. It could be a long time. The resources devoted right now to these types of audits are very slim. So we've seen auditors really become overwhelmed. Usually they're regional in nature. So you have an ICE auditor who's kind of over a particular region. And so there's a lot of things going on. It takes them a long time to get through these documents. Once that happens, they can issue all sorts of final documents to let you know kind of how the audit went, right? But the first thing you're going to get is a notice of inspection results. That document will kind of tell you overall what the auditor found, and then they're going to have a list of other notices that might accompany it, such as a notice of a suspect document. So if the documentation doesn't appear to say that the employee is work authorized, that notice will say maybe you need to go back to that employee and see if they have work authorization documentation. Notice of discrepancies, meaning they're in their system, they just can't seem to reconcile that this person is authorized to work. Again, directing you to go back to that person for additional information. Notice of technical or procedural failures. Those are things like you forgot to fill out information in the I-9. It wasn't signed on time. There were other errors on the form itself, those paperwork violations. Those could result in fines. Some of them may be corrected. If you correct those, if you take the actions written by the notices within the time period, usually it's 3 days, to rectify those errors, you will not be fined for them. But there's some that they'll still fine because you can't do anything to correct them. For example, the form has to be completed within 3 business days. And if you forgot to do that and Section 2 wasn't completed within those 3 business days, then you're going to be fined. There's nothing, you can't correct that because it's a temporal error. And then finally, you'll get a warning notice, which is great. You might get a warning notice, I should say. If you do, great. Pat yourself on the back because you got through it. That means we're warning you. We found some errors here. We saw that you corrected them, but just letting you know, we could fine you next time. So we're letting you off with a pass. Or a notice of intent to fine saying, here are all the errors. Here's the fine we intend to impose. When employers are audited, there's a couple of things. You should assess your you should first look through your documents, what documents are required, and determine if your 3-day timeline can be met. Sometimes the officers will negotiate with you if you say, man, I need more than 3 days. Can we get an extra week? A lot of officers, you can call them up, you can talk about it, and say, we need more time, and they may grant you an extension. Gather documentation and assess potential deficiencies. You want to know before, you'll be given the direction not to correct anything before you hand it over. But you still kind of want to know what could potentially come back. So it's a good thing to take a quick look at everything before you hand it over to the auditor or to the ICE agent. Consider consulting with legal counsel, even if just a few phone calls. Talk through everything with them. Talk through, is this normal? Am I responding correctly? Should I state something different here? The ICE auditor told us this. What should we do in this situation? Is always a good idea if you've never been through an audit to just talk to somebody who has. Understand that employers have the right to contest fines. So if you are fined, you do have the right to contest them if that happened. Finally, those sort of proactive steps to ensure compliance within your organization. I think it's really important to conduct those regular internal reviews. Look through your I-9s, even if it's just a spot check, pick out 20 randomly and just make sure that they're completed accurately and completely. Train HR and managers on Form I-9 completion and regularly retrain, right? Have every 2 years, everybody goes through a training, for example. Ensure compliance with the electronic completion, signing, and storage of Forms I-9. So there are separate rules for the I-9s that are electronically stored, electronically completed, and electronically signed. And those rules are very comprehensive. If you are using an I-9 software, most of them follow the rules, but not all. So it's good to just take a quick check and make sure that your I-9 software, for using it, is compliant with all of those electronic records requirements under the I-9 rules. Maintain and organized Form I-9 records. Keep them separate from employee files. So make sure they're all kept somewhere. If you keep paper forms, make sure to keep them away from employee files, or even if you don't store them electronically, so that you have easy access to them. Purge Forms I-9 after the retention period. So there's a wonderful calculator on USCIS's website. We should give that to you in the resources page after this recording. But that tells you how long to retain Forms I-9. It's 3 years or 1 year after termination, whichever is longer. But you can put in the calculator, lets you put in the date of hire, the date of termination, and it tells you the date that you can purge it. So I recommend purging those forms to get them out of your records as soon as you can, as soon as you hit that retention period.
But not too soon.
Yeah, not too soon. Not too soon. And then use E-Verify, question mark. Some states obviously mandate E-Verify. Some mandate E-Verify for certain types of employers. If you're a public employer, for example, E-Verify, I think there's going to be a push for broader compliance, broader usage of E-Verify. So if you are not using it, it might be something to think about. But again, the flip side of that is that sort of audit, you could be, it does use that algorithm. So you want to make sure your I-9s are being completed correctly, and you want to make sure that everything that gets entered into E-Verify is also correct. So it's an added tool for you all. It's an added protection, but also at the same time, you don't want to be using it incorrectly, because that information goes automatically to the government. Finally, and I think somebody asked about this too. So a note about TPS, and then it's not just TPS. There are some other immigration designations that I think are important for you all to know about. Temporary protected status is, you can read about it, and because we're running out of time, I just want to say that the administration is canceling TPS for a lot of individuals who are from certain countries. So if you're coming from a certain country and you have applied for temporary protected status and you have work authorization and the ability to be in the United States pursuant to TPS, this administration is pulling back a lot of those designations. They have the authority to do that. Every administration can expand or contract what countries are eligible for TPS, and this administration is pulling all of those back. So if TPS is canceled, employers are responsible for knowing that, one, hey, TPS designation for this particular country has been canceled. We're doing away with it. And everyone who has a work card under that TPS designation and from that country automatically now expires on April 25th. Then you need to, as the employer, you are responsible for knowing that. It's not the responsibility of the employee to tell you. You as the employer are responsible for knowing that. And then also at the same time, terminating them if they don't have another type of work authorization. So some employees have applied for another immigration benefit and they can still work for you, and you should ask them if they have any other documentation to allow them to continue working for you. But if they do not, it might be that they are need to be terminated for lack of work authorization at that point. The same goes with another program that's coming into place for EADs with the category code C11. So C11 category code is likely to end here pretty quickly as well. And those employees may not have work authorization beyond a certain date, which would be also in April. And more on that later, because it hasn't come down quite quite yet, but it's coming. We have a resource page. Again, we'll give you all the links to this that will have guidance on all of this, and we'll link it in the after the webinar. Okay, I have to do another poll question. We're gonna go through this quickly. All right, everyone, what's your biggest fear with I-9 completion? Tell us. You got it? You having difficulty understanding all the rules? The documentation is hard. Shouldn't the list of acceptable documents list all possible documents? Why are we required to know all of these rules about TPS? And then fear of the unknown.
While we're waiting, I just wanted to say that there was a question about, do we keep copies of documents or not? And it is best practice. And one of the reasons is, and I found this through audits, is that some of those errors that can be corrected can't be corrected if you don't have a copy of the document. So you have a higher penalty for those errors that can't be corrected. And so you can like drop it down to a lower fine or no fine if you actually have the backup document. So that is like the one plug for keeping documents.
And if you're using the new rules for reviewing documentation remotely via webcam, then you have to keep documents. There are document retention rules for those of you who also use E-Verify. So pay attention because you may be required to retain the documents. All right, close enough.
Yeah.
Fear of the unknown. Yeah, me too. Me too. All right, Tiffany.
Okay.
Tell us in 10 minutes, recent developments in travelers to visa restrictions.
I'm going to run through this, but please know that we have pieces that we're going to be dropping on our resource page about each of these things. And so you follow up. Okay, there we go. So one is non-citizen registration. I'll probably spend the most time. There's some visa restrictions and bans, which not have come up, but they're on the way. Some visa application issues and travel. So let's see here. The biggest thing is that as of April 11th, there's going to be a registration requirement for all non-citizens. And I mean, it comes from like the World War II. It's from a law from World War II, and that's being reactivated. But for most people that are here, or for people that are here lawfully, and for most of them, they won't have a registration requirement. They won't have to fill out a form and go get fingerprinted. So anyone here that has an I-94, so that entry document, an H-1B, an F-1, a J-1, a visitor, an athlete, they get an I-94 card when they enter, or a document that they can get from online. And so they're registered. All those folks that have the EAD card, so it's TPS, DACA, parolees, if they have an employment authorization card, then they've been considered registered. Those that have filed for adjustment of status, which is a green card, and have been fingerprinted, their receipt notice is their proof of registration. And then those that have kind of border crossing cards, that's the bulk of them. That's probably like 95% of all the people that don't have to register. And then basically everyone else will need to register by creating an account on my USCIS, which I've highlighted there. The big thing though is that everyone, whether they have a pre-existing registration or not, must carry documentation of that registration or pre-existing registration at all times starting April 11th. So that means always have to carry a green card, which has always been the rule, but carrying their EAD card, carrying their I-94 document. So maybe printing it on a small piece of paper and folding it up and putting it in a wallet or a phone case. Another big thing is that there's always been a requirement that one has to update their address with the USCIS when they move. That kind of continues, but the penalties are more severe now if they don't update, which includes, one of the penalties is removal, was deportation. So fines, jail time, and fines. So I'm not going to really talk about how you register, but again, we're dropping a piece about this online. And the next thing, we don't have a policy yet. We have a proposed policy, that's going to hit people from certain countries, either the whole, like all non-immigrants and maybe even some green card holders are going to be banned from entering the United States. So those are the red countries. I don't know how well you can see it on your screen, but, and then there's the orange, so certain visa types from those countries won't be able to enter. And then yellow are countries that might have some security issues now, and they're going to give the opportunity to rectify that situation. So they can either go off or they'll go into the orange or red. Let's see here. Okay. So obviously that may impact employers and schools, because you might have students from Pakistan who now can't come to the United States, or you might have someone that's traveling and they didn't make it back before the ban. So again, watch this space to see what actually drops when it does drop. We're going to skip the poll. Another thing is, and at first glance, this doesn't seem to apply to many people, maybe like, 0.1%, but it is a new visa rule targeting transgender individuals. But the way it is written, it could apply to everyone that applies for a non-immigrant visa at a consulate. So where the sex assigned at birth must match the gender marker in that application. And there are ramifications if they don't match. There may be delays in having to get additional, like your birth documentation. And there could be denials and maybe even bans from applying for visas in the future if it's taken to the extent that it is in the memo from the Secretary of State. So again, we're watching developments on that. Let's see. Okay. And then we are seeing, you probably heard a lot in the news about just entering the United States. So generally, CBP doesn't look at electronic documents, devices, maybe like 0.1% in fiscal year 2024 that they reviewed electronic devices. That's going to increase, and we are seeing that additional scrutiny. So it's really, they can look at anything on a phone on that device, but not in the cloud and not accessing the network. So think about a phone in airplane mode without Bluetooth or Wi-Fi. What is on that phone in that condition? And they have access to that without a warrant. That includes U.S. citizens, but they can't keep us out of the country. Whereas someone that doesn't want to give up their phone can be denied entry into the country. Okay, I did go by that fast. And so there's tips. Again, we're dropping something about travel tips probably sometime this week about what to do. And yeah, okay, and then wrap it up, Kelly. Sorry.
Look at that, 12:58. Well, Central Time for those of you in Central Time. So I'm gonna use this for shameless self-promotion. We have developed a resource page in our on our website that has a lot of resources for employers. It is divided in some cases out by industry. So there's some things that are directly affecting colleges and universities or healthcare organizations. If you are more concerned about I-9s, there's a 9-9 section. So we have a resource page. We'll be linking that. There will be several things dropping very soon. Some new content that will be up because there's a lot of new developments that have been happening. We'll be updating our information about track with these electronic device searches because I know that kind of heightens things. That's always been a thing that Customs and Border Protection could do for non-citizens. is search electronic devices. And so certainly that's something to pay attention to. This slide, I mean, I obviously we kind of included this section if we had time, but it's just, if we're thinking about, if you have people who are on visas, consider that everything is going to take a little bit longer. If you are applying for visas, if you're sponsoring for visas for any of your employees, that processing times are going to take a little bit longer. Cross-border travel could become a little bit difficult. And certainly, as Tiffany talked about, those travel bans could also place some additional hurdles on international travel. If you have additional questions, we are a wealth of knowledge and would love to hear from you. And we will, in our follow-up to this, again, we'll link to our resource page. We mentioned a lot of other websites as resources to you. We'll put all of that together. You'll get that as attendees of the webinar. And as I close this out, I want to say thank you. Thank you all for joining us today. We hope this information, although very fast and very furious and lots of content, was helpful to you and your organization. Again, the program has been approved for legal education hours. Click on that CEU icon if you need to report those hours at the bottom of the screen. You will get attendance along with the recording of the webinar tomorrow. You can share that, share the recording, share the slides with others. And then again, please, please, please complete the survey. Let us know what else you want to know about because we can drop more webinars, even of a shorter duration of topics that you're really interested in that we can do a more deep dive into. So please let us know. And again, thank you so much for joining us today. And we hope you have a good rest of your day. Thank you.
Thank you.